The first matter to come before the court this morning is Erick Jones versus Carrols LLC. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and wish to reserve that time, if you let me know at the beginning, I'm keeping the clock and will keep you apprised of your remaining rebuttal time. The court's read the briefs and we are ready to proceed when you are.
Thank you, Your Honor. May it please the court, Bob Kirkwood here for the appellant in this case. I would like to reserve 5 minutes for rebuttal. There was no valid enforceable arbitration agreement between Erick and Carrols or the individual defendants. In 2005, when Erick was hired in April, there was a mandatory arbitration program that was already in place at Burger King. That arbitration agreement required that in order to assent to the agreement, the employee had to sign the agreement. This was set forth in both the handbook, which was provided to the employee, and it was also a part of the policy manual, which was provided to the employees and which was located in each store or branch. Erick didn't agree to arbitrate and he didn't sign. At that point, he continued to work and Carrols took no action. Then in the summer of 2006, unilaterally, without Erick's consent, what basically Burger King did was they changed the agreement. So that now, as to existing employees like Erick, you didn't have to sign anymore. Simply, if you continued to work at Burger King after a certain date, they said that that meant that you agreed to arbitration. And Erick did continue to work after that day.
What's in the record of how the employee was presented with the written, the changes and information of that nature?
Well, in terms of the original arbitration program in 2005, it was supposed to be part of the employee orientation.
Well, you say supposed to be.
Right.
What do we know?
Well, we know for a fact, because from the record and from the testimony, there were 33 items that were supposed to be covered in that orientation. The record supports it that the orientation actually only took 10 to 15 minutes. Okay. Burger King, and so Erick basically never was presented with the arbitration agreement at the time. It was simply in the handbook. So he didn't sign at that time. Basically, by being able to unilaterally change the arbitration agreement without consent, without notice, without anything, for an existing employee, somebody that was already there, it is my position that that's an illusory contract, that basically there was no agreement because of that. In this specific case, the arbitration agreement said that the arbitration was supposed to be run by JAMS, J-A-M-S, which is a national organization which runs arbitration. And if you look at the JAMS rules, you will see that not only did Burger King have the unilateral right to change the agreement at any time without consent, JAMS also had the right to change the rules and regulations of how the arbitration occurred without consent. When you have that unilateral right, there is no contract. Moreover, there's no consideration. Erick was an existing employee, even though he was at will, he had employment. There was no additional consideration for entering the arbitration agreement at that time. So the contract was both illusory.
Wouldn't continued employment be the consideration?
Under Ohio law, my understanding is that in that situation it would not, simply because he was already working. He was an existing employee, which supposedly the consideration for his employment at that time was continued employment.
Did he have a contract?
He was an at-will employee, there was no employment contract. So there needed to be some kind of additional consideration for the change or modification in the arbitration agreement, and there wasn't any. Secondly, Erick never agreed, even assuming that the court would find that there was an arbitration agreement in effect, Erick never agreed to that. And there are several reasons for that. We know that. First of all, when he was asked to sign the original agreement, he didn't do it, and he wouldn't do it. Secondly,
Which agreement?
well, there was an original 2005 arbitration program.
So are you contending then that Carroll's statement that there was not a prior mandatory arbitration program is not correct?
That's not correct if you look at their own exhibits. Look at their exhibits 5 and 6. That is the handbook which was in effect when Mr. Jones was employed, and also the policy manual. And I have it here. I can read it to you. And basically, if you go to the handbook, which is, if you go to Exhibit 5, that was the handbook that was in place at the time that Erick was hired. And if you go to the table of contents there, I think it's on page 25, mandatory arbitration program. If you go to Exhibit 6, which is the policy manual, if you look at this, you'll go down, you'll see mandatory arbitration program, effective date, 9/15/05 and before. Now, Mr. Jones was hired in April of 2005, but the arbitration agreement that Burger King is trying to enforce didn't go into effect, and they didn't change it until August of 2006. So there was a program, the record itself shows that there was a program in place back in 2005. It's simply that Burger King decided to unilaterally change it, and change it from having to sign, showing that you agreed, to simply continuing to work, means you agreed. As I was saying, Erick never agreed to this. First of all, he never signed that original 2005 agreement. Secondly, there's no agreement here whatsoever between Erick and any of the individual defendants. The agreement that Burger King is trying to enforce is between Carrols Corporation and Erick Jones. There's no agreement signed by any of the individual defendants. And in fact, two of the defendants, and as this came out in the record, two of the defendants were not even employees of Burger King at the time that he was hired in 2006 when he allegedly agreed to arbitrate because he continued to work. Third, even if there was an arbitration agreement, some of Erick's claims weren't covered by the agreement. In his complaint, Erick alleges two claims that occurred after he was terminated. One occurred about 6 months after he was fired, and the second claim occurred in 2013, almost a year after he was fired. And it's pretty clear, and the case law is pretty clear, that post-termination claims aren't covered by an arbitration agreement. And that's especially the case here, simply because Burger King has always argued that it was the consideration for the arbitration agreement was employment. So if he wasn't employed, there certainly wouldn't be any consideration to support an arbitration of such a claim.
But those incidents occurred after his termination.
Yes, exactly. But also, the second claim that he had is a constitutional claim. It is Article 2, Section 34 of the Ohio Constitution, which provides remedies for employees in terms of their wage and hours and the information that they can obtain in that regard. Those constitutional claims were never included in the arbitration agreement. That is, there's nothing in the arbitration. It does list several different categories of what's covered by the arbitration agreement. A constitutional claim is not. And more importantly, the constitutional claim itself, the Constitution specifically states that the employee is entitled to a judicial remedy, that is, to be able to go into a court before a judge and to have full judicial appeal, and that the legislature cannot pass, and there can be no laws passed that restrict those rights.
Which section is that?
Article 2, Section 34.
Which part of Section 34? Because I didn't find that.
If you read the Haight case, I don't know what page it is on Article 2, Section 34, but it's directly in there.
It seems like the trial court's order doesn't address that issue of these other claims at all.
It doesn't.
Okay.
No.
But it was argued before the trial court?
It was well, it was brief, let me put it. What happened was basically we briefed it. The judge at the hearing said, all the briefs and the affidavits are incorporated. He made a very terse finding in terms of, really the only issue he determined was that there was reasonable notice and that it's not unconscionable. So there are at least two claims there that aren't covered by the arbitration agreement and wouldn't be subject to arbitration.
And you are just now reaching the 5 minutes. You may proceed or reserve as you see fit.
So I only have 5 minutes left.
Right.
Okay, I want to add one other thing. He never waived his right to a jury trial. There are no Ohio cases cited. I couldn't find anywhere this working is acceptance provision is found to be a waiver of a jury trial constitutional right. Basically, you need a written waiver to be able to waive a constitutional right at a jury trial. There's nothing signed here by Erick in any way that would waive the constitutional right. People shouldn't have to waive a constitutional right in order to keep their job. So I'll reserve my other 5 minutes for thank you for your support.
Good morning, Your Honors. Jeff Mayer on behalf of Carrols, as well as the individual appellees. To respond to some of the earlier questions first, the arbitration clause was presented in 3 separate ways, that's what the record shows. First, with a memo around August 1st, 2006, and that's supported by testimony of other employees who were there in the very restaurant. Also, that was
Our
posted.
memo sent how and to each employee?
Yes, and included the clause itself.
What memo? Was it a physical memo?
It was a physical memo that was distributed.
And how do we know everybody got it?
The testimony is that everybody received it.
Okay.
Additionally, there was a poster of the actual clause that was put up on the wall. The testimony was from the electronic records. It was Mr. Jones who came in that morning. It was his responsibility to open up the electronic mail, and it was his responsibility to post the poster. Additionally, there was a policy manual, and the arbitration clause was in the policy manual for 7 years. On top of those 3 copies of the actual clause, there was the employee handbook, which wasn't there to be the clause, but put people on notice, as well as the testimony that was verbal training that told everybody, including store employees at the time, about the clause. And there was no earlier program. The testimony of that was very clear. This was a factual argument made below. Before Carrols rolled out the arbitration program in August 2006, it did some spot tests, did not make it mandatory, and so some people signed just as a test program. There was no global program. That was rolled out in August of 2006. That was the testimony from multiple witnesses as well as the written record. Now, with regard to these other disputes, that was not argued below in any direct way, but it's very straightforward. To begin with, the arbitration clause says all disputes arising out of or relating to your employment, including those outside the scope of your employment. And it's written that way because otherwise you just plead around the clause and say, hey, it wasn't part of my job. So regardless of how the claim is phrased, Carrols as a defendant can only be in the case, only be liable. It's an artificial entity. It doesn't exist and run down the street and punch Mr. Jones because its agents or the company employed Mr. Jones. So if there's a claim against Carrols, it must by definition relate to his employment. If he wants to bring a separate claim against someone else, one of the individual defendants that said, you ran down the street after I left work and you punched me because we had a fight in a bar or for some other reason, that's a different claim. But even if it was the case that one claim could be peeled off, and there's no reason to think that any one of these claims does not fall directly within the scope of a clause that says all claims that relate to your employment at Carrols, when Carrols can only act by acting as his employer, regardless of what you call it. If you could call it some magic formula or name, and then say it's outside the clause, then it would disrupt 50 years of law and arbitration, which is arbitration is a social good. And that's where I think Mr. Kerper's arguments, however he wants to phrase them, have long been rejected, whether it's the argument that you can't waive a jury trial in an arbitration clause, or that it's unfair, or it shouldn't be done. The Ohio Supreme Court and the U.S. Supreme Court and the Federal Arbitration Act applies here to the extent it's inconsistent with Ohio law, which I don't believe it is. It's a social good. There are requirements that must be met under federal law, which is why certain of the cause of action are listed that are not required under Ohio law. For example, you have to specifically list Title VII claims and so forth. But one thing that I want to make clear, and that was going to be my first point, but I wanted to address Your Honor's questions, is all the reference in the brief to this being an unfair procedure or an unusual procedure are simply not accurate, supported by the record or any available case. There is no cost beyond the filing fee, which is partially reimbursed to someone who makes a claim. That's a requirement of federal law. There's testimony in the record from Mr. Lynn, who's participated in 2 arbitrations as a senior level person, who says there is no cost. Carrols pays for the arbitrator. Carrols pays for the room. The JAMS rules themselves preserve all of Mr. Jones's statutory remedies. If they did not, one, as JAMS says in their own rules, they would not conduct the arbitration. It's a requirement that Mr. Jones has every single remedy available to him in the arbitration. Otherwise,
Is this binding arbitration?
it's binding arbitration, yes. So the reality is, and if you look at all the cases across the country, and JAMS is a national organization, there is not one single case where there's even an argument made that the JAMS procedures are inappropriate for employment arbitration, or somehow unfair, or somehow don't meet the necessary fairness requirements of every single jurisdiction in the United States. And so, considering how litigious the country is and how vigorously people oppose arbitration, that's a remarkable fact. There simply is no basis to think on this record, on the idea of unconscionability or fairness, that if Mr. Jones presents his claim to a retired state or federal judge through JAMS, who by definition will have no relationship to Carrols, will cost him nothing, will occur near where he's located, with all his remedies preserved, will not have a fair opportunity to present his claim. So that leaves us with the idea of, as Your Honor said, did he agree to this program? And I think when you read through the record, and this is where Judge Gallagher's findings deserve deference, is that he did agree because he received reasonable notice. All the other arguments were made below and are not accurate. There wasn't an earlier program. There wasn't an illusory contract. Both Carrols and Mr. Jones agreed to arbitration. That alone is sufficient consideration, even leaving aside the fact that he continued to work at the company. Merely because he said he did not, and this is something that I want to correct as well. Mr. Jones's testimony was he never even heard of arbitration. So I don't think Mr. Kerber is justified today saying he declined to sign the clause. The record is he subjectively testified, I didn't even know this program existed. And I examined him on that. I said, even though the poster was up for 7 years, even though the policy was there for 7 years, even though you received a memo, even though your coworker said they attended training with you where the memo was presented, he goes, I never heard of it. So it's not accurate to say that the record supports the idea that he said, I don't want to participate, and then continued to work. That's not the record. So he did.
The fact of whether he received notice or not isn't relevant to whether or not the arbitration agreement is binding as to him with respect to the consideration of, if I continue to work here, I'm agreeing to be bound by it. Your client's position is because we are covered by the Federal Arbitration Act, he, ergo, is bound by it. Is that true?
No, our position is that the Federal Arbitration Act and Ohio law, which I believe is the same principle, certainly the Sixth Circuit cases we cited are, we think, persuasive authority, if not binding authority on the federal aspect. No, there needs to be a contract. It needs to be an agreement. That's what the Federal Arbitration Act says. It says people can agree with a written document to arbitration. It does not have to be signed. So our position is, under federal law and Ohio law, if we present a written arbitration clause, we did through a memo, a poster, and a policy for 7 years, and we say, if you continue to work here, you are bound by it, you're free to go work somewhere else, that forms a contract. And the test from the cases is not whether the person who does not want to arbitrate says subjectively, like Mr. Jones testified, I never heard of it. The test is, did the company provide reasonable notice such that a reasonable person would understand that they're bound by the arbitration program when they continue to work?
Well, the notice is separate, is it not, from whether or not the consideration of continuing in an employment with that company is consideration enough to form a binding contract. The notice is a separate consideration. Right?
They're related, but they're separate issues. They're related because if you never receive notice, then obviously continuing to work wouldn't be consideration. But if you are in a meeting and you have an arbitration clause and your manager says, I'll answer your questions, it says if you continue to work here, you're bound by this, and there's a poster that says it, and there's a policy that says it, and you opened up your computer and put the poster on the wall and checked for the poster for 7 years, the courts say, I'm not going to let you not arbitrate, which is a social good, because you come to court 7 years later and say, I never heard of this program.
Well, what if I saw that poster and I went straight to my attorney's office and said, can they compel me to arbitrate because I know about it and I'm going to go to work again tomorrow? And you're saying, yes, they can, that the case law supports that they can,
Yes,
without further consideration, compel him to arbitrate if he comes to work the following day.
Yes, that is our position. We believe the law on mandatory pre-dispute arbitration clauses is settled law. It is something that's permitted, with the caveat being, and that Judge Gallagher addressed this, being that like any other contract, you can't single out arbitration, but you can review any contract for unconscionability as long as you're using the same test as any other contract. And here, as you know, under Ohio, it's a two-pronged test, procedural and substantive. You have to meet both. And so unless the employee can say this is procedurally and substantively unconscionable, then it is binding. And that is settled law. If it was not binding, then it would completely unsettle the current state of employment law and employment arbitration. Because there is not a single case in existence now that says as a general rule, mandatory pre-dispute arbitration is not permitted. There's not one in any jurisdiction. And of course there's been, as with the plaintiff here today, says it's not fair or there's not adequate bargaining power. But the courts have answered that. The cases have answered that by saying, one, you're free to work somewhere else. But two, certainly under federal law, as well as Ohio state law and unconscionability, you can't force someone to participate in a process that's going to deprive them of their statutory rights. You preserve those rights, which this clause does.
And since 2006, everyone who is a new employee of this corporation has to sign the arbitration agreement, correct?
That is correct.
Upon hire.
Yes, and the testimony below was no one is aware of anyone who is currently working who has not signed. So for better or worse, as I argued in closing to Judge Gallagher, with 17,000 employees, the decision was made, because it was permitted by law, not to try to have 17,000 people sign at once, but instead post, send a memo, and put in the policy manual, and then have all future employees sign during their orientation.
Is Mr. Jones the only employee or former employee of the corporation who does not have a arbitration agreement signed? I'm sorry, that was a compound question.
We attached one case, which was the Green case in Florida, which was when Carrols no longer owns that concept, but it was the same situation. It was a pre-2006 employee who had not signed what was posted, resisted arbitration, and the federal court, in that case, enforced the arbitration program. There have been other pre-2006 employees have not, generally did not sign. And in all cases that I'm aware of, the clause has either been agreed to go to arbitration or, in the case of the Green case, enforced by a court. And certainly with, even on the unconscionability issue, Judge Davis enforced the Ford sign clause, which Mr. Kerper referenced, on motion without even hearing, and found that it was not unconscionable, and that case wasn't even appealed.
Well, the Green case says plaintiff notified the court of her agreement with defendants to arbitrate the dispute.
Yes,
So
what-
the issue of whether or not she was bound by it wasn't an issue in the Green case, was it?
After the briefing, after the briefing in that case, the plaintiff said, I will no longer contest the
Agreement?
assertions by Carrols. And so the court then entered, in essence, what was an agreed order, but the court, as a federal court, still had to reach a decision, but the issue had been fully briefed.
Since 2006, do you have any idea how many times Joy and Carrols have had arbitration?
Yes, because I think I've done every one of them. We've probably had 10 arbitrations overall, I will say, and this was the testimony of the 2 we've had in Ohio. We won one and we lost one. Probably had 2 or 3 this year and maybe one the other years. 2 in Ohio, though. And there've been it's been an issue in other cases that all were settled, so there've been other cases filed in different counties that never went beyond whatever initial discussions were, but they were motions filed. And none of the awards have ever been challenged in court.
Counsel, you have about 20 seconds remaining.
Yes, just the other point is the various other attacks on the clause, such as you can't say Carrols LLC is covered because Carrols Corporation is the owner, even though the language says that, or you can't cover third parties because it doesn't seem right, even though it's in the clause. Our position is those are all settled. If you can nitpick away at a clause and find an exception that gets rid of the presumption of arbitrability, lawyers are clever. You'll never be able to enforce an arbitration clause because there'll be endless litigation over that. So this is a fair result for everyone concerned, consistent with governing Ohio and federal law. We ask that the decision be affirmed.
Thank you. Counsel, you have about 4 minutes and 15 seconds.
Okay, thank you, Your Honor. May it please the court. First of all, in response to Judge Whitmer's question, there was never any testimony that Erick ever received the memo. He's testified.
As I understand the facts, that was not the only way in which this was communicated.
Correct. It was communicated by a memo, it's allegedly by a memo, and then there was this poster, which was in place. But the problem is the law is that notice is not it doesn't mean you agree. The problem here that Burger King has is that the memo and the poster are not the arbitration agreement. The arbitration agreement is a separate document. If you look at that document, there's nothing in that agreement that states that if you work after August 1st, 2006, you agreed to arbitrate. And there is nothing in the agreement, the arbitration agreement itself, that says that incorporates by reference either the memo or the poster. So if you look at the agreement, which is what we're talking about, there was no notice. But the thing here that I think the court needs to focus on is, he said that arbitration is a social good. Well, discrimination laws are social goods as well. Those kind of cases need to be held in public forum before a jury who can determine whether the practices of the employer were fair or not. So the fact that arbitration is permitted in this kind of case, we have a minimum wage employee who basically is supporting 5 children. He has a job. To come before this court and say, well, yeah, what he could say is, I don't want to arbitrate, so what I'm going to do is I'm going to give up my job in the hopes that I can find another one. That's not right. And nobody would expect a person in his situation to say that.
You said that there's nothing in the arbitration agreement that if you continue to work, you agree to the terms and the provisions.
If you continue to work after a certain date.
Right.
Correct.
Had that been in the arbitration agreement, would we be here? Would you be making the same argument?
I'd be making the same argument because I don't think there even was an agreement. I mean, there was the paper, which is alleged to be an arbitration agreement. But as I said, there was never actually an agreement because it was illusory. This arbitration agreement can be changed at any time without notice or consent. That's not an agreement.
Is one of your arguments that because of his financial situation, he shouldn't be forced to go to arbitration? Because certainly it's cheaper to arbitrate than it is to hire an attorney and go to a trial.
Well, not if you have it on a contingent fee. And it's not going to be cheaper here because it's pretty clear that there are some claims here that aren't covered by the arbitration agreement. So basically what you have is you're going to have Mr. Jones not only litigating a case in common pleas court, you're going to have him arbitrating against Carrols. That's not more efficient. The whole reason behind arbitration supposedly is, as the court indicates, it's supposed to be cheaper and more efficient. If he has to both litigate in common pleas court and arbitrate, it's not more efficient for him or the court.
If the claims arose outside of the scope of employment, then he would have to go to court in another case anyway, right?
Right. Well, no. I mean, if this court finds that he can agree to arbitrate, then he'd just be in court of laws.
No, I'm saying the claims that if he brought claims that arose outside of the scope of employment, he'd have to arbitrate, he'd have to litigate those separate from arbitration.
Well, but Burger King's arguing that those were covered. I mean, we're saying, yes, there are claims in his complaint that are outside the scope of arbitration, and that's one of the reasons why the court was wrong in dismissing this case.
How could the incidents that occurred 6 months and 12 months after his termination be within the scope of his employment when he was no longer employed?
Well, that's what I'm arguing. It's not. Burger King is arguing that the arbitration agreement includes those claims. And now our position is no, they're not included, and therefore it destroys really the whole efficiency of the arbitration procedure, because he's going to have to be litigating and arbitrating.
And counsel, you've reached the end of your
Okay,
allotted time.
thank you, then please report.
Thank you both for your presentations this morning. The court will take the matter under advisement and issue a written decision, which will be mailed to both sides as well as posted on our website and the Ohio Supreme Court website.